But if you'd said to Madison, we're going to have a system where they're dependent on the rich more than the poor in order to get to the House of Representatives, and constitutionally that's required. Nothing we can do about that. Would Madison have said, yeah, that's my First Amendment? Hell no.
But I think, again, that's misrepresenting what Federalist 52 is saying when it says dependent on the people alone, dependent on the votes of the people alone. But what we're doing with campaign finance is not regulating votes. We are regulating the information environment in which voters can reach decisions about who should represent them.
Somewhere I read of the freedom of speech.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights and Expression. Welcome back to So to Speak, the free speech podcast, where we take an uncensored look at the world of free expression through the law, philosophy, and stories that define your right to free speech. I'm your host, Nico Perino. In 2010, two landmark decisions transformed American campaign finance law. The first was Citizens United versus the Federal Election Commission, and the second was SpeechNow v. the FEC. Together, they cleared the way for corporations and so-called super PACs to raise and spend unlimited sums of money in elections. What followed was a new era in American politics, where individuals, corporations, and industries increasingly spent more and more money to influence campaigns and public opinion. Just last week, $33 million was spent in the Kentucky Republican primary between Representative Thomas Massie and his Trump-backed challenger Ed Galrein, making it the most expensive House primary race ever. This influx of spending has pushed some Americans to ask, is there too much money in politics? Supporters of the current system say no. In their view, money enables speech, and the First Amendment does not allow the government to restrict political speech simply because it's influential. However, critics argue that the system has concentrated political power in the hands of a wealthy few. Now, a case out of Maine could force courts to revisit one of the core assumptions behind the modern super PAC era. Today, we're joined by two guests who have spent years on opposite sides of this debate, or so I think, we'll see. Larry Lessig is a Harvard law professor, the founder of the nonprofit Equal Citizens, and one of the country's leading advocates for campaign finance. Larry, welcome onto the show.
Thanks for having me.
And Paul Sherman, here to my left, is a senior attorney at the Institute for Justice and served as co-counsel in SpeechNow.org, the case that helped create the modern super PAC framework. Paul, welcome onto the show.
My pleasure.
Both first-time guests. Larry, I want to start with you. What is your interest in campaign finance issues and issues of political speech and spending more generally? Where did this originate?
Well, it was literally almost 20 years ago. I had been doing work on the internet and copyright. And a friend of mine, Aaron Swartz, came and said, why do you think you're ever going to make any progress on the issues I was working on, so long as we have this deeply corrupt system for funding campaigns? And I said, it's not my field, Aaron. And he said, you mean as an academic? And I said, yeah, I do copyright. I do internet policy. I don't do campaign finance reform. And he said, well, what about as a citizen? Is it your field as a citizen? And I realized he had kind of cornered me because it was true. I didn't think there was any substantial reform we were going to see in those esoteric areas and fundamental areas like climate change or any other important area of policy, given the corrupting influence of money inside of our political system. So I promised him that night I would take up the fight. We lost Aaron to suicide.
I was going to ask, is this that same Aaron Swartz?
Yeah, it's the same Aaron Swartz. We lost him to suicide. And when we lost him to suicide, I said I was going to work on this until we had a substantial victory. So that's what I've been doing for 20 years.
So you haven't had your substantial victory yet?
We're about to, but not yet.
We'll discuss that. And Paul, what about you?
So my background in campaign finance started when I went to grad school. I have a master's degree in political campaigning. I think like most people, at the time, this was right around when the McCain-Feingold law was being debated and passed.
And what year was that?
Oh, I'm sorry. And this was around 2000, 2001.
Okay.
I think like most people, campaign finance regulation struck me as very common sense. I did see corruption in politics. I thought politicians were crooked. And campaign finance laws seemed to me to be a sensible way to address those problems. I had a professor at the University of Florida who challenged my views on that. And the more I read about it and the more I studied variation in campaign finance at the state level, I became much more skeptical. Eventually, I went to law school. Actually, the final exam question in my campaign finance class was, are contribution limits to super PACs constitutional or not? I argued they were unconstitutional. I got an A- in the class. I feel like in retrospect, maybe that should be adjusted.
Up or down?
Yeah, we'll see, I guess. And then eventually I went to work for a group then called the Center for Competitive Politics, now called the Institute for Free Speech. And at the time, they were developing the SpeechNow case with the Institute for Justice, where I work now.
So 2010 seemed to be a seminal year in the campaign finance debate. We got that Citizens United decision, of course, and we also got the SpeechNow.org decision, which came out of the D.C. Circuit, whereas the Citizens United case came out of the Supreme Court. Can you guys provide me with a little bit of background, and our listeners, of course, with a little bit of background around these two cases and their significance? Maybe, Larry, I'll start with you in the Citizens United case, and then I'll go to you, Paul, on the SpeechNow case, because you were co-counsel in it.
Yeah. Citizens United, of course, is one of the most famous Supreme Court cases. And
or infamous, depending on how you
infamous,
look at it.
exactly. And it is constantly pointed to as the reason we have super PACs. And I kind of feel bad for the lawyers in SpeechNow because I think, that credit doesn't belong to Citizens United's lawyers. It belongs to SpeechNow's lawyers because it wasn't Citizens United that created super PACs. Citizens United addressed the question whether a corporation or union or political action committee could spend unlimited amounts of money independently of a campaign. And it really was just an extension of a decision made in 1976, Buckley versus Vallejo, where the very same question was raised about rich people. Could you limit the amount that rich people spend independently of the campaign? And what the court said in Buckley was, no, you can't limit the amount they're going to spend because the only justification for regulating political speech was to avoid the risk of corruption. They said quid pro quo corruption. And if the money is independent, if there's no coordination between the spending and the campaign, then as Justice Kennedy would say in Citizens United, by definition, there's no risk of quid pro quo corruption.
There's no risk of this for that corruption.
Yeah,
if you give me this, I will give you that.
Because there's no coordination. Now, people forget the other side of that, which Buckley made very clear. If there is coordination, if you purport to spend this money independently, but it turns out there's a coordination, then that spending converts into a contribution to a campaign. So if you spend $10 million purportedly independently, but the FEC comes along and says, this was not independent, you guys were coordinating, that $10 million becomes a contribution to the campaign, which is obviously way beyond the limits you're allowed to contribute to a campaign. So you could be, in principle, criminally exposed because of that contribution. So there are two sides to this. It is independent, and as long as it's really independent, meaning not coordinated, you can't limit it because you have no justification for limiting it except the risk of corruption. Now, I think as a matter of logic, the case was not about factually what in fact happens in the world. It was a matter of logic. Kennedy said, by definition. I think as a matter of logic, it's fine. Yeah, of course. If there's no risk of corruption, and the only basis that you have for regulating is the risk of corruption, then you can't limit the expenditures. And that's all Citizens United established.
And how do you determine whether any coordination takes place? I mean, you could theoretically be a pretty savvy campaign and just put up a website that says, these are the messages we're trying to send. And then these independent, groups or corporations in this case, look at that and say, oh, that's what the candidate wants us to say, and says it.
Yeah. So it turns out to be
But there's no perhaps corruption.
There's no quid pro quo.
But there is coordination, perhaps, or like the suggestion. It's a way around perhaps the coordination.
Yeah, the point is the law has a pretty complicated set of understandings about what coordination is going to be. And the critical, practical thing to think about is if you're running, for example, a super PAC, you can direct your staff about what your staff is supposed to do to avoid any risk of corruption. Like, here are the things you can't be doing. Here are the people you can't be talking to. Here are the things you can't be talking about. And as long as the staff obeys that, then the Political Action Committee is not risking exposure from their expenditures being converted into a contribution. So it's relatively straightforward for them to be able to do.
And the FEC polices all this?
In theory. I mean, if we had an FEC, but,
that's
in
the
theory,
Federal Election Commission.
Yeah, that's their job.
And Paul, My understanding is that there's a lot of confusion around what the Citizens United case was really about. It was about a nonprofit corporation that wanted to make a movie about Hillary Clinton, right? And they wanted to release that movie within a certain period before the election?
Yeah, so the Citizens United case, actually a very interesting and underappreciated fact about it is that it didn't start as a case about the prohibition on corporate spending at all. It started purely as a case about disclosure of what are called electioneering communications. So
what's that mean, disclosure?
So disclosure is when you are required to report to the government and the government makes publicly available the name, identity, occupation, employer, and amount of money contributed by individuals or groups to certain types of political speakers or campaigns. So under federal law, if you give more than $200 to a federal candidate's campaign, your name, address, occupation, and employer goes on the FEC's website.
Okay.
And then that's aggregated on websites like Open Secrets and things like that. To deal with the fact that corporations had long been prohibited from making independent expenditures, corporations, of course, were coming right up to the line, and they were running ads that did not meet the definition of independent expenditure because they didn't explicitly say vote for or vote against. So in the McCain-Feingold law from 2001, they created this concept of electioneering communications, which were communications that mentioned candidates within a certain close period of time before the election. And corporations were prohibited from funding those, and people who did fund them had to disclose the donations that funded them. When the Citizens United case was filed, it was purely filed about the disclosure part of that.
Okay.
But actually, as it happened, the case evolved. Citizens United had the opportunity to run this documentary called Hillary the Movie. They had been planning to run it just in movie theaters, but they got the chance to do it on video on demand. And because cable television fell within the scope of the electioneering communications limit, that raised this question of whether the movie could be banned from cable TV because it was funded in part by corporate contributions to Citizens United.
And was the movie going to say anything about whether one should vote for Hillary Clinton or not, or was it just a movie about her career?
Well, so that I think that probably depends on who you ask.
Okay.
The way it would have been characterized, I think, by Citizens United is this is a purely factual documentary about kind of the qualities of Hillary Clinton. I think that's kind of dubious, even if no one was saying vote for or vote against. Probably people would have seen the documentary as what the Supreme Court referred to as the functional equivalent of express advocacy. So even though it doesn't have the words, everyone who's viewing it will see this as vote against Hillary Clinton, vote for her opponent. And the Supreme Court, for purposes of deciding the case, assumed that's what it was. It said, we're going to assume it's express advocacy. And then it reached the conclusion that Larry said, you still can't ban expenditures for this type of political advocacy just because the money comes from a corporation.
There was a very famous moment in the oral argument, right, where one of the justices asked someone representing the advocate representing the government whether this would also extend to books. So if this Hillary the movie was turned into Hillary the book, would that be expressed advocacy? And that seemed to kind of doom the case, right?
Yeah, so this was also an unusual case because it was argued twice, which almost never happens.
Why?
Well, I mean, there's some speculation about that. We don't know exactly why, but the first time it was argued, Assistant Solicitor General Malcolm Stewart argued for the government, trying to defend the restrictions, and he was asked this question, well, what if it was a book, funded by a union or a corporation?
Yeah, nonprofits, unions are all corporations.
Right.
Okay.
The whole book, is factual discussion, and then at the end it says vote for or vote against this candidate. Could you ban that book? And Stewart kind of hemmed and hawed and said, the restriction doesn't reach that. But when he was nailed down, he said, if the law were written to reach that kind of medium of communication, then yes, you could ban that book. And there was kind of a gasp in the courtroom. Justice Souter, who was no opponent of campaign finance restrictions, seemed very taken aback. And then for reasons that there's been speculation about, we don't quite know, the case was held over and re-argued the following term. now Justice Elena Kagan was actually the Solicitor General who argued the case. They said that they had reconsidered their view on that point. Souter had by this time left the court, and the court didn't buy it. It said that the same logic would apply to other types of communications. And that really was, I think, the rhetorical moment that lost them the case.
Yeah. And so I'm assuming you support the outcome in this decision?
I do support the outcome in Citizens United.
What about you, Larry?
Well, I think under the reasoning that says the only reason you can limit speech is the risk of quid pro quo corruption, it follows as a matter of logic. I think that's true. I mean, it's not my conception of what the First Amendment should be. In fact, I'm an originalist about the First Amendment. And I think under the original meaning of the First Amendment, you would have no ability of the court to be restricting campaign finance in this context. So I think this is a completely baseless field of jurisprudence. But, I just circulated a piece titled, If Roe, Then Buckley. I mean, there's no basis for, under an originalist theory, the ongoing jurisprudence of campaign finance. But assuming this is the framework, yeah, I think Citizens United is a true application of that framework.
Well, and if I can just jump in, I think that's an excellent point because one of the central tension in campaign finance law for the last 50 years has always been Buckley. Buckley is a decision that really split the baby. In the wake of Watergate, Congress enacts the Federal Election Campaign Act. For the first time, there are individual limits on political contributions at the federal level. And political expenditures. It goes to the Supreme Court, and the Supreme Court divides the analysis, and it strikes down the expenditure limits. It upholds the contribution limits. And basically no one in 50 years has ever been satisfied by this. I think Eugene Volokh is the only person I've seen who has suggested that may have been a reasonable way to divide it. But
Eugene Volokh satisfied?
But if you're on the reform side, you think that the expenditure limit holding was wrong. If you're on the, I don't want to use too loaded a term, but let's say the free speech side, you think that the contribution limit holding was wrong. And all of these difficulties that we have in line drawing essentially arise out of this division.
Yeah, Justice Thomas has been trying to get New York Times versus Sullivan struck down. And
so is Alan Dershowitz. He's got a petition before the Supreme
That's
Court, right?
Your
former colleague, I assume.
Right. And when he's doing this, he keeps on, telling us that New York Times versus Sullivan was, quote, policy-driven decision masquerading as constitutional law. And when I first read that, I thought, have you read Buckley versus Vallejo, Justice? I mean, this is a 144-page per curiam opinion. Not once does it try to explain to us what the original meaning of the First Amendment was and why this follows from the original meaning of the First Amendment. Instead, they divine this device, this corruption device, which they think is like the true measure of whether you can have campaign finance reform laws or not. And so again, under that principle, I think Citizens United follows. I don't think there's any problem with Citizens United. What doesn't follow is SpeechNow. What doesn't follow is that even though you can have limitations on you can't have limitations on expenditures, it doesn't follow as a matter of logic under the reasoning of Citizens United and Buckley that you can't have limitations on contributions.
Well, that's a good segue to turn now to the SpeechNow case, which you were co-counsel in, Paul. What was the purpose of this case, and was it, as Larry says, to strike down the contribution limits to these independent political action committees that aren't coordinating with a campaign?
Yeah, so the purpose of SpeechNow was to target a very specific, what we thought was illogic, that had persisted since the decision in Buckley versus Vallejo. So among the limits that Buckley imposed was a limit on individual expenditures. So a wealthy person could not spend more than, I don't know if it was $5,000, who knows? All the numbers have changed over the years. Wealthy people were capped in how much they could spend advocating the defeat or election of federal candidates.
And that's independently of
independently
of a contribution.
Because as Larry said, if it's not independent, it's a contribution.
Sure.
Or that's the way it's treated. So the Supreme Court struck that down. So a billionaire can spend $1 billion on political advocacy. But if you and I and Larry were to get together and want to do the same thing, we would be limited to $5,000 apiece, because at that point, when you have more than one person, you're a PAC, a political committee, and you're subject to contribution limits. And that just didn't make sense to us. If it's fine for Bill Gates to spend $1 billion, it should be fine for us to get together and throw in $10,000 a piece or more. That was the way we framed it. And, we developed the case in 2008, actually before Citizens United was about the contribution or the corporate expenditures. And the case was structured in such a way that it would avoid the issues that were directly related to corporations. So SpeechNow's charter did not allow it to accept corporate contributions. It was structured as an unincorporated nonprofit association in the District of Columbia. And our argument was really based on these earlier decisions, there's a case from the 1980s, Citizens Against Rent Control v. City of Berkeley, which was about contribution limits to ballot issue committees. That was the structure of the case. And then a week before oral argument at the D.C. Circuit, Citizens United comes down. And then the first question that Judge Sentell asked my colleague, Steve Simpson, was, what do you have to tell us that Justice Kennedy didn't say or didn't resolve last week? And Steve, said, well, not much, Your Honor. And it was kind of a foregone conclusion at that point.
But Larry, you say that Citizens United, the logic of Citizens United shouldn't have reached the SpeechNow case at all, right?
Yes.
And that the first question probably shouldn't have been about Citizens United because it was not related. How so?
I mean, I've spent a lot of time reading that argument. It's quite an extraordinary argument. First of all,
this is the transcript
from the oral argument. Yeah. Because first of all, your side basically got no chance to address the corruption issue. They spent most of the argument trying to deal with the disclosure question, which went on and on and on. And then when the other side got up, they got to get to the corruption issue. But I think the FEC's lawyer or the government's lawyer made a really fundamental mistake because the core question Judge Sentell and Judge Ginsburg were trying to figure out was, what was the corruption interest in regulating contributions if you could not regulate expenditures? And there's this extraordinary passage where the lawyer for the government goes through examples of where you had independent expenditures that were part of a quid pro quo. He had 3 examples where it was clear that there was an illegal bribe, but it was an independent expenditure. And Judge Kavanaugh, now Justice Kavanaugh, said that would all still be true of an individual's independent expenditures as well. And he said, the lawyer for the government said, yes. The answer to that is no, that's not true. Because if there's a quid pro quo, as we said before, that means it's not independent expenditure. And if it's not an independent expenditure, then that's a contribution. It's an illegal contribution because it's way beyond the limits of the contribution. So the point was, the lawyer didn't help the court understand that there's a coordination rule with expenditures. The rule says you can't coordinate. And if you do coordinate, then your expenditure is regulated to be a contribution. But there's no coordination rule, no complete coordination rule in the context of a contribution. I could sit down as a billionaire, I could sit down with a candidate and I could say to the candidate, geez, we got to figure out how we're going to get, these crazy Republicans out of office. And I think what I can do is if you're willing to help me on the widget bill, I can, put another $50 million in the committee to get. So there's a coordination, but the rules governing super PACs have nothing to say about that. It has something to say if he says it to me, the candidate says it to me as the billionaire. But if I say it to him, there's no coordination rule. So the point is, what Citizens United said was, by definition, there's no risk of corruption. Why? Because there's no coordination. See Buckley. And in Buckley, the court said, the reason we don't have to worry about quid pro quo if there's no coordination is that there's no opportunity for the quid pro quo. And then Buckley said, but if there is coordination, then there is a risk of quid pro quo. And so therefore, then you can regulate. And what the D.C. Circuit Court of Appeals did, and again, it doesn't come from your words, it comes just from Judge Sentell. Judge said, in light of the court's holding, Supreme Court's holding, as a matter of law, so logical, we're talking about fact, not talking about facts, we're talking about logic, that independent expenditures do not corrupt or create the appearance of quid pro quo corruption. That part, I think, is true. Then goes on to say, contributions to groups that make only independent expenditures also cannot corrupt or create the appearance of corruption. That part's false because there's not the equivalent coordination structure in place over the contribution that there is over the expenditure. And indeed, what we've seen since, my favorite United States Senator, Robert Menendez, in 2015 was indicted. His indictment was he engaged in a quid pro quo bribe with a Florida businessman. He said to the Florida businessman, I'll give you these government favors if you send money to my super PAC. So there it was, a quid pro quo involving a contribution to a super PAC. Menendez's lawyers had the chutzpah to file a motion to dismiss, saying, the thing you've indicted us for, the D.C. Circuit says cannot happen, so therefore we must be innocent. And of course, they chuckled at that, but they didn't dismiss the indictment. But the point is that revealed the logical mistake that Judge Sentelle has made. And SpeechNow was never appealed to the Supreme Court. They didn't take it up because the Attorney General at the time thought it's a tiny amount of money. There's no reason to worry about it because it's not really significant, not recognizing that once you remove the limits, it would become the most consequential category of speech. But it's never gone to the court. The court's never taken it up. And immediately after SpeechNow, 4 other circuits basically parroted exactly what Judge Sentelle had said there's no risk of quid pro quo corruption with a contribution to an independent political action committee. That was the foundation that gave us super PACs. Now, in our case, we got an initiative passed in Maine. We got it on the ballot, then they ran the campaign and got passed in Maine with 75% of the voters supporting it.
The largest support for a ballot initiative ever, right?
The largest number of people to vote for anything in the history of Maine, any candidate or any initiative, 600,000 votes in favor of this. Because in Maine, a very purple state, it's not a political issue. It's not a left-right issue. I gathered signatures for this on Election Day 2023. The first guy to come up to me said, I'm here getting signatures to put Donald Trump on the ballot. What are you here doing? And I said, here's my initiative. And he read it and he said, hell yeah. And he signed it. And he said, I'm going to get everybody signing my petition to come over and sign your initiative, which he did for the 3 hours he was there. Every Trumper came over and signed my initiative. So it's not a political issue in Maine. But immediately after it passed, 2 super PACs in Maine filed a lawsuit against it, and the district court enjoined it. Now, what's so amazing about the district court's decision is that every other court had said there's no risk of quid pro quo corruption with a contribution to an independent political action committee. The district court said, even accepting that contributions to independent expenditure PACs can serve as the quid in a quid pro quo arrangement. So she acknowledged, Neil Katyal was our lawyer, he was arguing, he got her to see, absolutely, a contribution to an independent political action committee could be part of a quid pro quo. Still, she constructed some radically new theory about the First Amendment to hold that even though there's an acknowledged risk of quid pro quo corruption not regulated by the system of campaign finance that we've got, the state nonetheless could do nothing about it. And I think that's the most extreme opinion we've ever seen. And when the First Circuit gets a chance to address it, they've never considered this question before, they're going to see it's a clear mistake.
When are they addressing it? Do we have a date for oral argument?
We don't. The briefs have been completed since February. We expect, I think that they're waiting so that the clerks don't change midway through the case. So the earliest we would hear it would be the end of July.
Paul, I want to give you an opportunity to respond, but before we do, I want to just put a finer point on the logic of Buckley, right? Because it said it can regulate quid pro quo corruption, but also the appearance of corruption?
That's right, yeah. So
there doesn't actually have to be any quid pro quo corruption or the opportunity for it, but if the electorate fears there might be corruption or has a sense that there might be corruption or if there's vibes that there's corruption, that could also be regulated?
I think vibes is kind of the best way to explain it. And subsequent Supreme Court decisions kind of into the 90s also had a very vibes-based feel. Basically corruption, as the Supreme Court has defined it, has always been kind of the classic bribery quid pro quo. And then appearance is—
And that is like the Senator Menendez case?
The Senator Menendez situation. Interesting, there have been situations, basically anything of value can be a quid. People have been prosecuted for accepting sexual favors as a quid. Don Siegelman, former governor of Georgia, Arkansas?
Somewhere. You can Google it, listeners.
In the late 1990s, was prosecuted for soliciting a contribution to a ballot issue committee. He solicited a $500,000 contribution to a ballot issue committee. That was a quid in the quid pro quo. So those direct kind of agreements can be banned as bribery, and bribery has been banned, since time immemorial. Appearance of corruption has always been sort of defined vaguely in the sense of it has this dispiriting influence. It causes people to lose trust in government. I think it's proved to be very problematic because it's very much in the eye of the beholder, but also because we are not really a political culture that is based on a tremendous amount of unearned trust in government. I mean, there's a certain amount of distrust in government that is healthy and necessary, because otherwise, they'll lead you off the end of the cliff. I think one of the things that we've seen, starting with Citizens United, even a little before that, and moving closer to today, is that the Supreme Court is bumping up against this frustration with trying to police the appearance of corruption. And they're paring it back and paring it back and paring it back to something that is more objective and looks more like bribery.
Okay, but can I just make sure that you said something that I think it's really important to be clear about. You said that there's an appearance of corruption even if there's not actually a possibility of corruption.
I think you know where I was trying to go with Paul, but go there, please.
I mean, so the point is, I think it's appropriate under the court's framing to say that an appearance of corruption has got to be tied to an appearance of quid pro quo corruption, right? And when you read Buckley is all about, my gosh, if the public sees that big favors are being given in exchange for big contributions, they will just believe that nothing more than money matters. So, not to be too controversial here, but look at the pardon practice that's going on in the White House right now. Like huge amounts of money being contributed to super PACs, and in exchange, all of these convicted felons are being granted pardons. I think the public looking at that legitimately could say, this is just a system where you buy your justice, and that is the appearance of corruption, but it's the appearance of quid pro quo corruption. It's not the appearance of some other theory of corruption. I have lots of theories of corruption. I would love it if we could regulate, but we don't. Just it's an appearance of quid pro quo corruption, and I think that's exactly the kind of anxiety that Buckley was worried about.
So let me ask you the question directly, Paul. This is a two-part question, a compound question, as you might say. The first is, how do you respond to Larry's argument that super PACs have enabled or can enable the sort of quid pro quo corruption that the Buckley court talked about? And then second to that, even if you put that aside and we're talking about the vibes of the appearance of corruption, and you look at Elon Musk spending $290 million on the last presidential election, I mean, that to me is just kind of a lay listener or lay viewer of the situation say, I mean, even if that's not corruption, the appearance is certainly there. He spent $290 million to get this guy elected. He then became a special government employee to run Doge. He's flying on Air Force One. He seems to be involved in everything the president does. He spent all this money in Pennsylvania, which was most important to the president. I mean, even if there was no this for that direct coordination, there still appears to be something going on there. So how would you respond to those two arguments?
Yeah. So, first, I think that Larry makes a very sophisticated argument for this possibility of quid pro quo corruption. And I'm willing to concede for purposes of the argument that there is some loose language in both SpeechNow and Citizens United. I'll just say there's some loose language in both of those opinions. If I were writing them, I probably would have written them differently. Where I think I would differ with him is whether the mere possibility that someone can arrange a quid pro quo through giving a contribution to a super PAC is enough in itself to justify limits on all contributions to super PACs. And I think I would disagree with that. And part of I think the natural experiment that we have is what I alluded to earlier with the ballot issue committees. So ballot issue committees have been allowed to raise unlimited amounts for over 40 years. Once the Supreme Court held that, spending on ballot issues exploded. Candidates are very often tightly connected to specific ballot issues. And we have one example of quid pro quo corruption in that context.
That was from the case from the
and
90s.
That was the Siegelman case.
And just to define what a ballot initiative, this was the sort of initiative that you ran in Maine, which would have capped contributions to super PACs at what, $5,000,
Yep.
right, Larry?
Yeah.
Okay, sorry, Paul.
Now, it may be the case that the government has the power to create a concept of something like coordinated contributions, which does not exist under current campaign finance law, which would treat those differently to avoid this kind of circumvention concern. But there's also a requirement for what's called tailoring in the First Amendment, where when you are regulating things that touch on political speech, you have to regulate narrowly and impose the smallest burden possible, and an across-the-board limit on speech, most of which is conceitedly not corrupt. I think that's going to fail the type of tailoring that the Supreme Court applies.
So, but
Go ahead,
this
Larry.
It's really helpful in clarifying this, because the point the court was making in identifying the risk of quid pro quo corruption in Citizens United was a logical point, and it should have been clearer, because the immediate reaction everybody had was the kind of roll your eye reaction. So Elon Musk spends $10 million in a Wisconsin election for Supreme Court justice, and he says it's independent. And people say, oh, yeah, right, it's independent. And they just don't believe it's independent. And the thing that should have been said after that is, this is not an unregulated expenditure, because if it turns out not to be independent, it's an illegal contribution. So the scheme that exists in the context of expenditures is not just libertarian. It's not just you can do what you want. It's heavily regulated. You do what you want if and only if you are not coordinating. And if you are coordinating, then you are regulated. So I think the court could have pointed to that and said, that's why we don't believe there's a risk of quid pro quo corruption. Of course, it could happen, but you face exposure if it happens. So we think it's fair to say that this doesn't create the risk of quid pro quo corruption. But in the context of contributions, as you've said, there's no such regulation. So why do we believe that there's not coordination in this context? Now, you've rightly said, and many have made this point, well, okay, imagine we had a rule, a coordination rule, said you can't coordinate. But the principle you've identified, the narrowing tailoring principle, cuts in my direction. Because you couldn't imagine a rule that said supporters of a candidate can't coordinate with a candidate. That's ridiculous. That's a wild invasion of the free speech rights of people who are involved in campaigns. So that rule would be wildly invasive of the protection the First Amendment is supposed to give. So you need a narrower rule. And this is what Buckley justified contribution limits with. Buckley said, we can't, there's no way the government can find all quid pro quo corruptions that are going on out there. And the point is, if the public thinks it's reasonable that there's quid pro quo corruption going on out there because there's no limits on the amount you can give, and so obviously rich businessmen are going to come in and dump money on politicians as they have through the beginning of time. Therefore, the least restrictive way to create an environment where no sane person believes that the politicians are selling their votes is contribution limits. The same justification in direct contribution limits is the only rational remedy in the context of independent political action committees, because you can't ban coordination. You can't achieve it in any other way.
Paul, I want you to respond to that, but Larry, I'd like you to confirm something for me, because I'm trying to understand the rules regulating campaign finance in this way. So you're saying there are coordination rules as to regard independent expenditures, but there are not as to contributions. So if you run for president, which you did, and I want to donate to your super PAC, if we're talking about that donation.
Let's be very careful. I mean, because the rules are ridiculous.
Yeah,
this
gets crazy.
And that's why I'm trying to unpack this for our listeners, because it is complicated.
So the point is, so if there's a super PAC, the Lessig for President super PAC, I tried to become a candidate, but when they changed the rules to ban me from the debates, I stepped aside. But the point is, imagine there's a Lessig for President super PAC. The Lessig for President super PAC is not allowed to talk to the Lessig campaign. They can't coordinate our spending. They can't say, you cover New Hampshire and we'll cover South Carolina. That kind of coordination can't happen. But the FEC has created a rule that says they can fundraise together. Okay, and in the fundraising,
So if I'm the political action committee, I can have you, the candidate, come to the fundraiser to raise money for our super PAC.
I, as the candidate, this is such a scary part of my life, so I just want to stop this whole metaphor here for a second. Like, I, as the candidate, am not allowed to get up and say, give $50 million to the Lessig for President super PAC. Right? I'm not allowed to say that because that's above the contribution limit that would be to my campaign. But the runner of the super PAC can stand up and say, we need to raise $1 billion in this race. So you need to contribute $100 million, everybody in this room, to make sure that we have. And there's no problem in that context with the, quote, coordination. It is unregulated.
So pretty much the FEC just has to kind of parse the transcript to see if you said the wrong thing.
Yeah, if I said the wrong thing, then there's a problem with what I said, and what follows from that is not even clear. But the point is, it's not a context where it's unreasonable to believe that there's quid pro quo corruption going on. Whereas in the independent expenditure context, because of the world of regulation, it is unreasonable to believe that there's a kind of quid pro quo corruption going on. Or at least if we had an FEC enforcing the law, it would be unreasonable to believe because everybody's facing exposure. Other way to think about it is, look, let's say you're running a super PAC. You tell your staff, here's what you need to do to make sure that we are not coordinating, make sure that we don't face penalties because of our expenditures. Make sure that our $50 million expenditure doesn't turn into a $50 million contribution. Here's a list of the 10 things not to do. But then you receive a contribution in the mail for $10 million. You have no way to know what the backstory for that contribution is. So whereas you can make sure you're not coordinating the expenditure so that there's no risk of corruption, you can't know as the committee whether there's a coordination in the contribution. Which means the thing the Supreme Court has said again and again, where there's a risk of that quid pro quo corruption, you can stem the risk, and you need to go through the least restrictive means test to do it. And the court in Buckley said the least restrictive means test is a limit on contributions. You can't enforce that in the context of contributions with coordination rules because of the First Amendment. So therefore, contribution limits and coordination for the Independent Political Action Committee follows from Buckley, follows from Citizens United, which is why I get so angry when I listen to my friend Bernie Sanders talk about this issue, because Bernie Sanders will constantly say, super PACs have destroyed American democracy. I'm okay with that part. But they don't go on to say, therefore, the Supreme Court needs to overturn Citizens United, which drives me nuts, because not only is it impossible, like this court is not overturning Citizens United, just not going to happen. It's also unnecessary. What I hope the court does is write an opinion that says Citizens United has been criticized by lots of people. See Bernie Sanders, who says it's the worst decision in the modern period. But there's nothing wrong with Citizens United. We reaffirm the logic of Citizens United. But under the logic of Citizens United, nothing says that a contribution can't be limited as opposed to an expenditure because there's a risk of coordination, and therefore there's a risk of quid pro quo corruption. See Buckley, see Citizens United. Therefore, Senator Sanders, you're wrong about Citizens United, but Maine, you're right. You can limit the size of contributions to independent political action committees. Therefore, super PACs are dead.
Paul, I promised I would come back to you. We've gone further afield from that previous discussion in the last 5 minutes here, but I'd let you respond to kind of anything that was said there.
Well, so there was a lot, and I'm probably going to miss some stuff. But I think one of the things I would say is that, in my opinion, that read of Buckley, well, number one, I think it puts a lot of faith on Buckley's continued vitality, which is, I think, somewhat in question. I think if the contribution limit issue gets to the Supreme Court again, one of the things that we've seen is they seem to be pushing against that further and further and further.
That was one of my later questions. Is the contribution limit to candidates the next domino to fall?
It's certainly there are people litigating those cases, and it's if I had to bet, I wouldn't put my money on the continued vitality of Buckley v. Vallejo. But
that would be tough for your case.
I think,
right, Larry? Go ahead.
Well, so
I have a lot to say to that, but I don't want to
let's go.
So I think, the context of Buckley, those statements is focused on contributions to candidates, candidate committees, and to PACs that are making contributions to candidates. But in other contexts, for example, like the ballot issue committees, contributions to those have been treated as sacrosanct and can't be limited in any way, even though, as we've established, they can be a quid in a quid pro quo. So I think this also touches on something the Supreme Court has said in numerous recent decisions about this concept of prophylaxis on prophylaxis, that we have these contribution limits to candidates, we have contribution limits to political parties, but each step you take that's further removed from that, the amount of corruption that you're reducing is more and more attenuated, while at the same time you're imposing greater burdens on political speech and independent political speech in particular. So I think if this goes to the Supreme Court, they may agree with Larry that Citizens United is not the dispositive thing. It doesn't control. But I absolutely disagree that they're going to say that limits on contributions to super PACs are constitutional.
Okay, but so first of all, let's talk about the attenuated point. The president in April of 2024 stands up before a group of oil executives and says, if you raise $1 billion for me, I will relax oil regulations on day one. The only way to raise $1 billion in that context is through a super PAC. So the idea that the super PAC is more attenuated than the law telling me I can't give $15,000 to a candidate running for office because there's a risk of corruption for me is just crazy talk. Of course, super PACs are not the attenuated risk of corruption today. They are the core risk of corruption today. That is the mechanism through which corruption happens, and this president has demonstrated that over and over again. Now, you're right. There are a lot of people who look at this court and say, this court is going to blow up everything. They're just going to blow up all limits. They're going to double down, triple down on the libertarian conception of the First Amendment. And I want to say, by what freaking right? Like, what authority? Because, those originalists, Justice Thomas, who says, decide this the way it would have been decided under the original understanding of the First Amendment. The original understanding of the First Amendment would never have policed Congress's ability to define the scope of regulation over the integrity of the election system. I mean, and my support for this, let me just start with my second favorite senator, Senator Josh Hawley, who in 2023 introduced a bill to overturn Citizens United. What was his argument? As any originalist knows, the original meaning of the First Amendment would never have limited Congress's ability to control how corporations spend their money. Huzzah, exactly right. The original meaning of the First Amendment would not regulate these laws. They would not give the court the authority to strike down these laws. I'm an old originalist. I clerked for Scalia at the beginning of his career. Scalia was a Robert Bork, stop the activist judges originalist. Bork's best friend, Alex Bickel at the Yale Law School, talked about the counter-majoritarian difficulty, the deviant institution that judicial review is. And the basic rule was, if you don't have a clear basis for mucking about with the laws of Congress or the laws of state legislatures, then sit the frick down. You have no authority to be striking down these democratic laws unless the Constitution tells you can. And the interpretation that Buckley created, some might say like the interpretation Roe created, of the Constitution has no connection to the original meaning of the First Amendment. So I want to say to these originalists, where do you get off? Justice Thomas, where do you get off saying we should overturn New York Times versus Sullivan? Because the original meaning of the First Amendment would never have authorized that, but you get to say we're going to become complete libertarians in the context of campaign finance reform, because the First Amendment originally understood didn't cover that either. So I want to have that fight with them, because I don't think they have any basis for the assertion they're making that they have the authority to strike down these laws under the conception they want to teach us they're practicing of the original meaning of the Constitution.
Well, Larry says he wants to have a fight here, Paul. Are you an originalist? No, a rhetorical fight, not a literal fight. Are you an originalist, and do you think there's originalist arguments for the position that the SpeechNow court took in this case? And I want to also ask you, if we're looking at originalism from the theory of like text history and tradition, what is the tradition of campaign finance regulation throughout, let's say, the late 18th and 19th century?
Yeah. So as a litigator, I have the luxury of not having to identify a judicial philosophy I ascribe to, because when I go into court, basically what I'm doing is arguing about precedent and how it should be interpreted. Now, I think it's useful to take a step back, though, and say, what is it that we are regulating at its core when we regulate super PACs? And when we regulate super PACs, we are imposing limits on people's ability to pool their resources to talk directly to voters about what issues they should care about and which candidates they should elect. That is activity at the very core of what the First Amendment is supposed to protect, at least under anything like the conception of it that we've had throughout the 20th century. Now, in terms of text history and tradition, campaign finance is very much a creature not only of the 20th century, but the late 20th century. We have the Tillman Act in 1907, which prohibits corporations from giving money directly to candidates, but it's not really enforced. We have Taft-Hartley later in the 20th century, which regulates expenditures by corporations and unions, again, not really enforced. And it's not until FICA that we have in 1970s this novel federal comprehensive regulation of how people fund political expression in America.
Wait, so Paul, is what you're saying here for the 19th century, money could just be thrown around elections willy-nilly? There was really no regulation, or maybe there was state-level regulation? I mean,
There was.
I'm just trying to understand for our listeners what regulation existed in
there was some state level regulation that started to be passed in kind of the late 19th century. Part of the reason why there wasn't regulation is simply because campaigns were less expensive. You didn't have mass media. Today we live in an environment where there are, tens, hundreds of millions more voters in America who you have to reach and try and persuade. And the only way to do that is through mass communication, and that's expensive.
So I think this is exactly backwards. I mean, the reality is, throughout our history, until 1976, states and the federal government got to pass laws regulating the integrity of the political process however they want. They were never subject to constitutional review. 76 is the first time that we have the United States Supreme Court, Zeus-like, deciding this whole new conception of how they're going to be allowing states and the federal government to regulate the integrity of our political system. And they pull out of their hat this corruption standard. 144 pages of an opinion, not telling us anything about the original meaning of the First Amendment. Now, that began the reality that we've had today. We've had 50 years of campaign finance jurisprudence, just like Roe gave us 50 years of abortion regulation. And I think the point is, in both contexts, one should ask the question, what is the constitutional foundation for this? Because the original meaning of the First Amendment, you say it's the core idea of the First Amendment. That's not a true description of the original meaning of the First Amendment. The original meaning of the First Amendment said, Congress shall make no law abridging the freedom of speech. From a modern perspective, we look at that and we say, what is the freedom of speech? That seems really lazy of them, not to enumerate precisely what they meant by the freedom of speech. But what they meant, as people like Jamal Green or Judd Campbell or Jonathan Gannett have demonstrated again and again, what they meant by that, as Justice Thomas, who cited Judd Campbell in his opinion, Judd Campbell's research, what they meant was the freedom of speech can't be regulated. And there were some clear cases, like prior restraints. So if the Congress passed a prior restraint, the framers probably believed the judges could come in and strike it down. But beyond that, the representatives, we the people, got to define what the scope of the freedom of speech was. That was the original understanding. So the point is, if Congress passes FICA, this campaign finance law, because that's its conception of how to make sure that we have a system which is not viewed as a corrupt system, under the original meaning of the First Amendment, the judges should sit the frick down. They should have nothing to do with this. It's not their job, as Thomas said in the context of New York Times versus Sullivan. It's not their job to make up a whole theory of how the Constitution should be and then impose it on the legislative branch. You and I might agree, actually. I mean, I kind of like the idea that courts get to review this. But the point is, that's not the framers' understanding. And if you're going to be a consistent originalist, consistent to your originalism, then you ought to at least have the courage of your convictions. And I think this court especially, because people look at this court and they say, oh yeah, originalism is comfortable whenever it benefits the right wing, but it's ignored when it doesn't benefit the right wing. And so, evangelical Christians loved Roe being overturned. That's where originalism has its role. But when we turn to campaign finance, all of a sudden we're no longer an originalist, no longer concerned about what the original meaning of the First Amendment is. And I think there's no legitimate basis for them to be selective like that. I think it's unprincipled. And I think they've just never had to confront that question. And if they do, I'm not sure that there aren't, I think there are great justices like Amy Coney Barrett, who clerked for Scalia and is in this sense a Scalia wannabe. I think Scalia very much wanted early in his career to demonstrate his philosophy was not political, it was principled. The last time I saw him, last time I had lunch with him, I said, you ruined me as a law professor. And he laughed. He said, what do you mean? And I said, when I clerked for you, there are any number of times where there was a conflict between the originalist answer and the conservative answer. And in every one of those cases, you did the originalist thing over the conservative thing. And so when I became a law professor, I predicted every time you would do the originalist thing over the conservative thing. And
what year did you clerk for him?
I clerked OT 90, so 1991.
Okay, so that would have been the Eichmann case. So that was the previous term.
Yeah, previous term. So he laughed, and I said, but you've let me down every time. And he laughed and he said, give me an example. And I said, campaign finance right here. And so the point is, I think if you are an originalist on that court trying to think, what actually is the original meaning of the First Amendment and how do I continue to respect it now? You have no sanction, no authority, no right to strike down laws of Congress or the people of Maine in the name of a constitution that we the people never ratified. No time in our history did we the people rise up and say, yes, we want to protect the aristocratic power of wealthy people in our democracy. That is a constitutional principle of ours. To the contrary, James Madison in Federalist 52 said, we would have a house that would be, quote, dependent on the people alone. And in 57, he said, by the people, he meant not the rich more than the poor. I mean, the idea that this libertarian First Amendment is the First Amendment James Madison penned is to say that James Madison was a deep hypocrite. On the one hand, he's saying we're not going to have an aristocracy, but on the other hand, his First Amendment guarantees a aristocracy because it guarantees the rich are more powerful than the poor, that they are dependent on the rich more than the poor, rather than dependent on the people.
Paul, does he have the originalist argument right?
But let's talk about Federalist 52 and 57, because the language in Federalist 52 is a comparison of the House of Representatives and who the electors are for the House of Representatives, not who's speaking to those electors. And it's contrasting it with the Senate and the electors who choose the president. And in 57, when he talks about not the rich or the poor, he's talking about who is allowed to run for the House of Representatives, not who is allowed to speak to them and try and persuade them
but
in their votes. And if I can, I think Madison would have had to have been hopelessly naive not to think at the time he was drafting the Constitution that political elites and wealthy people were going to be influential, more so than the common person, on who people are going to vote. That's why in Federalist 10, when he talks about faction, he says that the solution to that is not to try and restrict faction, which I think campaign finance law does, but to let faction counteract faction and then ultimately put our trust in the voters so that they can throw out the candidates who we think violate their trust.
Okay, but the point is, there's nothing in what Madison says that suggests he believes he's passing a First Amendment that would disable Congress from addressing that problem if that problem arose. I mean, as you pointed out early in the campaigns, they were not expensive. In fact, candidates didn't campaign. Other people campaigned for them. So it wasn't a problem at the founding. But the point is, nothing in his First Amendment disables that. And yes, Federalist 52 is comparing the different kinds of representative or electors. But the critical language is dependent on the people alone. He's building a system where he wants the House to be dependent on the people. And yeah, Federalist 57 is talking about rich versus poor in a different context. But if you'd said to Madison, we're going to have a system where they're dependent on the rich more than the poor in order to get to the House of Representatives, and constitutionally that's required, nothing we can do about that. Would Madison have said, yeah, that's my First Amendment? Hell no.
But I think, again, that's misrepresenting what Federalist 52 is saying when it says dependent on the people alone, dependent on the votes of the people alone. But what we're doing with campaign finance is not regulating votes. We are regulating the information environment in which voters can reach decisions about who should represent them.
Right.
And so who is the government or some portion of the government to say, you are not allowed to consider this voice. You have heard too much of this voice before you cast your vote.
Okay, but again, I mean, you've been very careful, and I appreciate it during this conversation, not to mischaracterize what an attempt to limit the size of contributions is. Like, what this rule would mean is that Elon Musk couldn't give $250 million to a super PAC. But it doesn't mean he can't spend his money as he wishes, of course. That's protected by Buckley. That's protected by Citizens United. So he can spend his money independently. We're only talking about these machines of what we think of as corruption. That's number one. But number two, the question is not what Madison might have thought or not thought about what would have happened in the future. The question is, did Madison manifest that his First Amendment disabled the Democratic branches from addressing this problem if it came up? What in the founding moment, when we the people created higher law around the First Amendment, ratifies the idea that we are disabling legislatures from addressing the myriad problems nobody could begin to imagine in 1791? And my answer is there's nothing in their Constitution to suggest that's what they were doing. Indeed, their conception of the First Amendment was Congress within these extreme cases got to define what the freedom of speech was. And they made big mistakes. The Alien and Sedition Act, I think everybody thinks was a mistake. But when they passed it, Madison and Jefferson didn't go to court and try to get a court to strike it down. They thought that's ridiculous. We can't go to a court and get it to strike it down. They tried to create this mechanism through the states where the states passed these resolutions to declare that this was not the Constitution. So that's what they expected. You would have a political process for deciding the scope of freedom of speech, not a judicial process.
But Larry, is that correct? Because my understanding of their objections to the Alien and Sedition Act, or the Sedition Act in particular, was that they thought this was an exercise of unenumerated powers, that Congress didn't have this power to regulate speech in that way.
It's both. They talk about both. And I think that's an open question still. Like, we got to talk about what the scope, what the source of the power is for them to pass.
But I only bring that up because you are saying that it's very clear that they have this power within the scope of the freedom of speech.
Well, what I'm saying is clear. What I'm saying is clear is that when they defined the freedom of speech, that raises two questions. What is the substantive scope of the freedom of speech? And they were not simplistic about this. It's not like they thought nothing could violate the First Amendment or everything would violate.
See, my question about this is there's just not much in the record about what they thought.
But that's my point. Let's give me the second point. So the first point is, what's the substance?
Sure.
But the second question is procedural. Who gets to decide?
Got it.
And so the point is what, Campbell, Gannep, Jamal Green, what these people have demonstrated through the historical record is they understood that the procedure, the person who gets, the entity that gets to decide is the representative body itself. That's as opposed to the judges. Now, we've decided it's not the representative body, it's the judges. And so my claim is the originalist would say, the judges? What are you talking about? Where is that? Like, why would you ever expect the judges get to decide what the freedom of speech was? Given your really good point, it's really unclear what the scope of the freedom of speech is. Certain clear cases. Certainly you can't have a prior restraint. Maybe you can't punish somebody for merely like expressing their views contrary to the views of the government, the point you were making before. Maybe that's core fundamental idea that maybe a judge would have the authority to articulate on. But beyond that, no. That wasn't their Constitution.
Last point here before I let you get in, Paul, and then we have to wrap up in the next 5 minutes or so. But when you're looking at the First Amendment, don't you have some scholars like Stephen Solomon and Leonard Levy, who later changed his mind after writing Legacy of Suppression, say, no, actually, when you look at it and how people actually behaved, that these were some, they had a more expansive view of the First Amendment's free speech clause.
Yeah, I think that they had a very...
So there is a debate within the academic literature between the kind of Judd Campbell side on one side and the Stephen Solomon.
Well, that's not the debate that there exists. There's a debate, about the extent to which they would have thought that certain questions could have been answered by judges. So the question of the thickness of the firm foundation.
But isn't the First Amendment and the Bill of Rights more generally an anti-majoritarian document that's supposed to set off these questions from what the majority might decide?
Right. But that's, again, the reason why it's important to distinguish the substance from who gets to say. So substance, I completely agree with you. There's a very rich conception of freedom of speech, substantively. And so they would say on the floor of Congress, you can't do this because it's going to violate freedom of speech. You can't regulate in that space. But the question, who gets to say what the scope of the freedom of speech is a different question. And what we've decided is it's judges. 9 elected judges get to decide what the scope of freedom of speech is. And we have this incredibly elaborate, not just in the campaign finance doctrine, but in the last 60 years, incredibly elaborate doctrine that, has okay, the judges get to decide. Why do the judges get to decide? This is Justice Thomas policy making dressed up as constitutional law.
It's funny. It's funny you say this because I was recently reading a transcript of an interview that the Justice Hugo Black did, where he was talking about the free speech clause of the First Amendment. And he says, If you just asked somebody on the street what Congress shall make no law abridging the freedom of speech means, he'd say, well, makes no law. It seems pretty obvious here. So you're focusing on the freedom of speech part of that, and Hugo Black is focusing on the make no law part of that. Hugo Black wasn't very principled on this. The Cohen v. California case, for example, he said, if there was speech he doesn't like, he just found some way to call it conduct, but we'll put that over there. Even there, he's trying to define what the freedom of speech is by distinguishing between speech and conduct.
Exactly.
But Paul, sorry, Larry and I have been going back and forth here for a second. I want to give you an opportunity to chime in here. Again, on the original meaning of the First Amendment and whether that argument comes down on your side or Larry's side.
Well, I think.
And then I have one more question before we wrap up.
I'm not a historical scholar, but one of the things that this discussion has kind of prompted me to think about is if we're going to be originalists about the First Amendment in kind of the way that you're discussing, I think we also have to acknowledge that there are a tremendous number of exercises of power that our government is engaged in that are totally just not justified by the text of the Constitution. And my own belief is that to the extent campaign finance is an issue in this country, it is largely downstream of unaccountable government power. Ants don't attract picnics, right? It's the other way around. If you have an unaccountable amount of government power that can determine people's financial lives, their fate, destroy entire industries, create entire industries, people are going to try.
I hear there's a new slush fund that I'm going to petition to get a piece of.
Yeah, no kidding. People are going to try and influence that. And I think they have a moral right to try and influence that because it can be used to destroy them. Now, again, that envisions a government that has a lot less power. And to some people, that's not an acceptable compromise. What they want to try to have is something like the amount of power that government has today with no corruption. Now, I think campaign finance laws don't actually contribute in any meaningful way to fighting corruption or the appearance of corruption. We could talk about that for another 3 hours based on looking at the different state regimes of campaign finance. But what I will say is, now I'm sorry.
I do have a question because we're talking about corruption here. I do have a kind of a broader question about election outcomes. So you spend all this money to speak, as you would say, or maybe perhaps to get access if you're Elon Musk. I don't know. I don't know the motives. Maybe it's probably a mix of both in these cases. How much does money actually influence the outcome of elections? Because I think that's what a lot of lay people see is that all this money in elections are skewing the outcomes of elections. And they're thinking of that as a form of corruption rather than the kind of quid pro quo that we've been talking about for most of this conversation.
I don't think the outcome question is the corruption. It's the dependence question. Because I once thought Evan Bayh addressed this question where somebody said there's no good showing that money actually has an effect on the outcomes or even effect on legislation. He says that is the most naive perspective on Washington that I've ever heard. He said every single politician is desperately terrified that somebody's going to drop $1 million against them in the election, the last week of the election. So what do? They make sure that they've got $1 million on their side in reserve that they can call on if they need it. And how do they buy that insurance, that kind of super PAC insurance? Well, like all of us, you got to pay your premiums in advance. So how do you pay your premiums? You vote in the way that these people want you to vote so that you know they will have your back if $1 million is dropped on the other side. So I don't care. I don't have any view on whether the money actually is going to make this person elected or not. What I do have a view on is that the politicians are constantly aware who's spending money and who's not, who are they fearful of and who can they count on. And the way that they make sure that they've got the people lined up they need to line up is to shapeshift in the direction of the money.
Paul, if I have this right, your side would say they're fearful of speech in that case. Who's going to spend all this money to speak? Do I have that right? And Evan Bayh, he was a senator, right? Yeah, senator.
Yeah, so I think that's right. I have a few thoughts on that. One, I completely agree. The best empirical evidence shows that the spending basically has no impact at the presidential level. It can have some impact on—
Did Hillary Clinton spend more than Donald Trump? Yeah.
Mm-hmm. Yeah.
Was it a lot more?
Yeah. It can have some effect on down-ballot races. One of the things that it can do, kind of analogous to what Ross Perot did in 1992, is it can inject issues and make people talk about them when the candidates themselves would prefer not to. As to Larry's point, I think there are so many other structural factors that contribute to that to a greater degree. Like that's the entire public choice literature about concentrated benefits, diffuse costs. Industry spends much more on lobbying than it does on political contributions. And if we assume, as Milton Friedman would suggest, that they're trying to maximize their profits and they're rational actors, they're doing that because they think the lobbying is better at getting them the policy they want than the campaign contributions.
Yeah, so I completely agree with you about that. I think crony capitalism is the worst flaw inside of our system right now. We've got to end the crony capitalism.
Hear, hear.
So how do you end the crony capitalism? Well, shut off the money in the elections, because it's the election. This is the way the politicians extort money out of the people they're trying to regulate. Like they sit down and they say, let's talk about your policy issue. But actually what it is a fundraising breakfast where they're only going to allow you to sit around the table if you've come with $100,000 you've bundled from some other place. So if you shut that down, then the whole mechanism that's driving crony capitalism, I think, disappears. That's number one. Second point is, look, the question is not the policy question. We might agree on the policy question. The question is the constitutional question. Where in our Constitution does it forbid legislatures or the people in Maine from erecting whatever scheme they want to erect to try to address what is the general perception that money is a problem? Pew, for the first time in February of 2025, found 72% said that money was a very big problem, the highest of all the economic issues they had. For the first time, people thought that. Why? Because you can't look at the world right now in Washington with this president and not think that money is driving an extraordinary amount of what this government does, and they don't want it like that. So where did we, the people, ever say, you're stopped? You can't do anything to address that problem because that would force the government to be picking sides in speech. Never. We never said that. And so if we didn't say that, we the people never said that. If it was never embedded in the Constitution, legislatures should be allowed to experiment as they want to try to address a problem that we all see as a problem now.
Paul, I'll give you the last word.
I would say that's a radically limited view of the First Amendment, particularly in comparison to the way the Supreme Court looks at it today. Now, maybe that's the view you want, but that would empower the government not just to regulate campaign finance, but a tremendous amount of speech that for decades we have considered to be outside the control of the government. Whether or not that's justifiable as an originalist matter, something I can't really opine on. As a free speech advocate, that's something that I have to oppose.
Let's just recognize we're recording this the day after the government effectively threatened a broadcaster because of the jokes that the broadcaster had on their show. So Stephen Colbert's last show was last night. So you and I are agreeing about the policy judgment there. That's a terrible thing, that the government would be able to exercise its power to stifle one particular perspective. We're totally agreed on it. The question is, does Congress have the power to pass laws that might disagree with your view of free speech and my view of free speech? And I think it's better that Congress be in that position than 5 justices on the Supreme Court. They're not elected. Their judgments don't get tested by anything other than who happens to be appointed to sit with them.
Well, this conversation isn't going away. We have a midterm election coming up here in November. We've also got a Supreme Court decision that is pending in National Republican Senatorial Committee, the FEC, which involves, if I have this right, the coordination on expenditures between a political committee, political parties committee, yeah, and the candidates that they support. And then we also have your case, right? Yeah. Which this is DTA, Dinner Table Action v. Schneider case, which is now pending before the First Circuit. We're waiting for an oral argument, and you think that's probably going to be late summer, early fall. So we will stay tuned for that. Lots of what we discuss here will be in the show notes. Larry, you said you have an article. What was it, Buckley and Reno?
No, it says, if Roe, then Buckley.
And is that published? Can we put that in the show notes?
SSRN, we'll put it on the show notes. Yeah, you can get the draft of it right now.
Perfect. Well, Paul, thanks for coming on the show. Larry, thanks for coming on the show. I am Nico Perino, and this podcast is recorded and edited by a rotating roster of my FIRE colleagues, including Bruce Jones, Ronald Baez, Jackson Flegel, and Scott Rogers. The podcast is produced by Emily Beeman. To learn more about So to Speak, you can subscribe to our YouTube channel or Substack page, both of which feature video versions of this conversation. We're also on X, where there is a video of this conversation, and you can find that channel by searching for Free Speech Talk. You can send us feedback. If you have feedback for Larry or Paul, we'll make sure we get it in front of them. That feedback can be sent to sotospeak@fire.org. And if you enjoyed this episode, please leave us a review on Apple Podcasts or Spotify. Reviews help us attract new listeners to the show. And until next time, I thank you all again for listening. The Foundation for Individual Rights and Expression, FIRE, and the Flame logo are registered trademarks of the Foundation for Individual Rights and Expression.